you.
Yes, after having looked at the directive, just a few general points before we move to the cases, and in relation to whether the point of statutory construction is whether temporarily means short-term on one hand or non-permanent. The first point is that the directive, neither the directive nor the implementing regulations make any reference to short-term at all. They use the phrase temporarily. In our submission, both Ryanair and MCG are effectively inviting the court to rewrite Regulation 3.1a to read worker is supplied to work short-term for and under the supervision of the hirer. And we say there's no warrant for that. And the next point is that if the EU or the domestic legislation was only ever intended to apply to agency workers working short term, it would be relatively straightforward for that to be made explicitly clear. The next point, again, we've covered this in some detail in the skeleton argument, but we've considered, shown the court the provisions concerning equal treatment under contained within Article 5. And the fundamental point is, as a social protection measure, in accordance with the case law of the European Court, it must be interpreted as having a broad reach. We've referred to a number of authorities in the skeleton argument at paragraph 28. If I could just provide the court with one reference without referring to it, it's Del Chero Alonso, which deals with the principle of equal treatment under the fixed term framework agreement. It's divider 24 and it's paragraphs 27 and 38. And the general headline proposition is principle of equal treatment should not be interpreted restrictively.
Just remind me, what were the terms that were not said to be equal, in respect of which the original claim was made?
Oh, yes. Just bear with me one moment. So it's in the core bundle, divider 19, and the grounds of complaint start at page 308.
Yes.
And page 316. And my Lord, to answer your Lordship's question, it's paragraph 46 sets out what constitutes relevant terms and conditions.
Yes, really what it boils down to is annual leave, which is just another route to the same result as the other claim. Paid annual leave, is that right?
My Lord, no. Paragraph 47.
Yeah, I was about to come. I was doing them the wrong way round. But 49. That's. Am I muddling myself?
It's only 4 weeks under cat work. This is 28 days.
So a directly employed Ryanair pilot would be contractually entitled to 28 days leave.
And 28 days isn't the same as 4 weeks? Well, I don't know. Sorry?
I'm sorry.
My Lord, no, there's an argument to say it's not.
I see, that's debatable,
yes.
If we ever get there.
Yes.
Yes, I see. And then otherwise, pay, he says differences of pay, but he says, I'll need disclosure. So he doesn't actually... So really, the only solid claim under here is about paid annual leave, which may or may not, but there may be others. Is that right?
My Lord, I put it no higher, but there is a strong belief or understanding that a Ryanair pilot would earn more favourable basic pay.
Right, okay.
Because you'll recall from the contract that Mr. Lutz gets paid per...
Yes, no, you may well be right. I just wanted to... We're talking at a very high level of generality. I just wanted to remind myself what the actual disparities alleged or suggested were. And you've answered that. Thank you.
And then the final point to make, and following on from the purpose of the directive, to interpret temporarily as meaning not permanent aligns and chimes with the protective purpose of the directive. And the consequence of the appeal by Ryanair and MCG is this: if they're right, there are three categories of agency worker: permanent agency workers, short-term agency workers, and the third category would be long-term agency workers. Now, the third group on both of their cases wouldn't be protected under the directive. They would also not qualify for any protection under the fixed-term framework directive. And just by way of an aside, Mr. Lutz couldn't in any event bring a claim under the fixed-term regulations of 2002 because he is not an employee. It's limited to employees rather than workers. And Mr. Lutz...
Is that consistent with the directive?
It is, yes. Or at least...
okay, no, well, let's not have a red herring. I was just surprised. It just surprised me. So, but I will contain my curiosity.
Well, my Lord, if I can put it this way, I'm not aware that it's ever been challenged, albeit maybe too late now. But the way it's been transposed is limited to those who have employment status rather than wider workers.
Okay.
So we had indefinite workers and fixed-term workers as the first distinction that you drew to our attention, with temporary agency workers being left off to be dealt with subsequently. We then have a directive about temporary agency workers. So you've got three categories there. What is it about people who do fixed-term work through a temporary agency that aligns them with temporary agencies?
My Lord, my understanding is that when the social partners were negotiating the framework agreement, it may have been a bit too complicated to include or to extend the rights to equal treatment in a tripartite agency worker situation, which is why they deferred the issue and brought in protection subsequently in relation to the directive applicable to temporary agency work.
But fixed-term workers who are engaged by the end user have the protection of the fixed-term directive.
My Lord, no, they don't. Sorry, if I can perhaps just reverse and address it slightly more slowly. In order to bring a claim domestically under the fixed-term employees regulations, the clue is in the title employee. You've got to be employed.
I don't think that was my Lord's point.
Yes.
My Lord wasn't making a distinction between workers and employees. So have I got that right?
Absolutely. I was saying, as I understood it, a fixed-term employee who is employed by Ryanair has that category of protections, but a fixed-term worker who is employed through an agency doesn't qualify because he's not an agent, he's not an employee. But you say he's to be equated with a temporary agency worker.
Yes.
I just wonder what it is that, where you've got these three categories and somebody is in the middle. What moves him into the temporary agency worker category?
My Lord,
as distinct from someone who simply hasn't been thought about.
My Lord, it's simply this. There was a clear and conscious decision to exclude that category of individual from the framework directive, and it was considered that they needed specific protection in the form of the directive on temporary agency work. That was the mechanism by which the EU institutions sought to afford them the rights to equal treatment. So
Is it your proposition that the temporary agency workers directive was intended to fill the entirety of the lacuna left, avowedly left, by the fixed term directive?
My Lord, that is the point, yes. So they were taken out of the scope of the fixed term because the social partners couldn't reach agreement at the time or it was too complicated. And they acknowledged that they would be addressing the situation, and then you have the directive on temporary agency work. So it comes about by design. And the key point is really this. In circumstances where temporary agency workers were intentionally excluded from the framework agreement, called fixed term work, and the European institutions passed the directive specifically intended to afford agency workers protection, it would be a surprising result if it resulted in people like Mr. Lutz falling completely outside of scope. It would be a surprising omission.
Is this another way of putting it? That the policy of the community legislators, as reflected by the recitals and the agreements, was essentially that people who were not on the classic indefinite employment contract, which it regards as the norm or the paradigm for workers, should have a degree of protection. Effectively, the main one being equal rights with people who are on that form of contract. And there are two classes of people who are not in that position. One, people who are directly employed but fixed term. And secondly, people who are employed through an agency, whether fixed term or otherwise.
Yes.
And you say one can see from the legislative history that the intention was to bring, though albeit by two different pieces of legislation separated by some years, to bring the entirety of that class into the protections afforded by the two sets of directives.
My Lord.
Have I got that right?
Yes, entirely.
I'm not sure that answers my Lord's question or not, but...
All right, well, let's go.
No, my Lord, I'm happy. If the question could be repeated, apologies.
No, I think I've understood what you're saying. Thank you very much.
Sorry to interrupt again, Mr. Britton. Can I ask a nerdy question? Do we get any help from the other language versions? The word temporary.
The lady, Advocate General Sharpston.
Advocate General Sharpston does a bit of that.
Does a bit of that.
The French and the Italian do it first.
And then when we come to it, I think the Advocate General in Daimler was also a footnote and it was reference to Bulgarian. But
I'm sure my lady wants it in all 27 communities. Gaelic,
Not
particularly.
necessarily.
we still haven't found anything in relation to Greek. But lady, perhaps I was going to move on to JH and KG.
I don't want to waste your time.
No.
I just because we could flag up or something. I'm curious about.
So JH and KG, if we start with the Advocate General, it's at divider 45. And And before we just look at certain passages, the court's been shown some already. It's necessary to perhaps clarify what this case is actually about, what KG is. It is about abuses under Article 5.5 involving the successive assignments of JH. And
In which case is this K?
this is, we call it KG, it's the Advocate General tab 45.
Yeah, okay.
And tab 45, page 861, we can see that at paragraph 2, the Advocate General's opinion starts off by referring to Article 31 of the Charter. Made the point that indicates a broad reach. Paragraph 3 refers to
So I'm still checking
page
out.
862.
862, yeah. Yes.
So paragraph 3, third line down, refers to the aim of the directive is to establish a protective framework and to ensure compliance, ensure full compliance with Article 31 of the Charter. So not partial, but full. And paragraph 4 refers to recital 15, which we've already touched upon, reference to contracts of indefinite duration.
So I've got lost again. Where are we?
Paragraph 4 refers to recital 15,
Yes, yep.
which we've looked at. And then in terms of the facts, very briefly, this is page 864. And under domestic Italian law, it's the last paragraph on page 864 under paragraph 18. But Italian law provided, I can perhaps paraphrase the last paragraph, that where as a result of succession of fixed-term contracts for the performance of equivalent tasks, an employment relationship between the same employer and the same worker continues for an overall period of more than 36 months, it will be regarded as a relationship of indefinite duration. So that was the context, background context. And in terms of the facts, page 865, paragraph 21, JH was a machine and lathe worker supplied between March 2014 and November 2016 with successive contracts for the temporary supply of work. So there were 8 successive contracts and 17 extensions. And we can see from paragraph 22 that he brought proceedings seeking to declare the existence of an employment relationship between him and the end user. And the difficulty he faced under domestic law is set out in paragraph 23, and it's 5 lines down. The referring court states that the domestic law is inapplicable as it only governs the relationship between temporary agency workers and temporary work agencies, not between the agency worker and end user. So that was the problem that JH encountered. The questions that were referred to the court are set out at paragraph 25. And Advocate General Sharpston addresses this at page 867, it's paragraph 33 onwards. But in doing so, addresses the questions framed by reference to what she describes as the broader context in paragraph 34. And again, at paragraph 38, you can see in the first line reference to the directive establishing a protective framework. and a reference to the Article 2, which we've already looked at, the aims of the directive. Over the page to paragraph 40, again, Advocate General Sharpston considers the aims or the purposes of the directive. Those provisions bring temporary agency work closer to usual employment relationships. It's clear that the starting point of the directive is that the general form of employment relationship is, and I add should be, employment contracts of indefinite duration. So we can see that theme running through both the framework directive.
So is that's you saying should be, is it?
No, that's
Where are you reading
paragraph 40.
Yes, while those it is clear.
Third line.
Yeah.
And I should
Sorry, yes, thank you.
Yes, so she says, and I add should be, employment contracts of indefinite duration. The directive therefore aims to stimulate temporary agency workers' access to permanent employment at the user undertaking and refers to Article 6. But
Permanent employment at the user undertaking,
yes,
not by the end user.
well, that it means the same.
Yes,
It is the hirer, if we use domestic language. And there's a reference there to Article 6, and you may recall before lunch, that was the right of an agency worker to be informed or notified of permanent vacancies at the user undertaking. But again, we see the same theme or the same distinction as features in the framework directive on fixed term work, the reference to the usual form of employment being that of indefinite or permanent duration. Paragraph 42, there's a reference to the principle of equal treatment by reference to Article 5. And then over the page to page 869, the Advocate General deals with or addresses Article 5.5. We can see at paragraph 45 that it requires member states to take appropriate measures to prevent misuse, the application of Article 5, and in particular to prevent successive assignments designed to circumvent the provisions of the directive. So that's what the KG case was about. And what the Advocate General addresses this further at paragraph 49. Against that background, Article 5.5, she asked the question, does Article 5.5 impose an obligation for member states to prevent successive assignments that are designed to circumvent the provisions of the directive so as to ensure the temporary agency work and the same user undertaking does not all too easily become a permanent situation into which the temporary agency workers are trapped. The trap that she's referring to is the not being employed in an indefinite employment relationship or a permanent relationship and not having the security of that employment. That is the trap. Paragraph 50 and 51, again in relation to the wider context, the Advocate General considers what is meant by temporarily. Paragraph 50 refers to the risk of tautology, and paragraph 51 is centrally relied upon by Mr. Lutz. The very title of the directive makes clear the employment relationships it covers and are by definition supposed to be temporary. That term is used in the provisions defining the scope of the directive, its purpose, as well as in the definitions of the key terms in Article 3.1 B, C, D and E. The word temporary means lasting only for a limited period of time, not permanent. And then there is the reference to the footnote and the Oxford Dictionary of English and the other language versions, in particular French and Italian. And then, by reference to...
Hang on 1 second, sorry, I'm not pretending to be very good at either language, but intérimaire is actually the word used, although there is a word temporaire, as we see from the second line, that's not the word used.
I would have to defer to your lordship.
I'm just trying to answer, but it has a concept of interim. I suspect interinale in the Italian is a misprint for intemorale. Anyway, okay, thank you. I don't want to spend any more time. I just wanted... It does help a little.
The key point is that definition of lasting only a limited period of time, not permanent, that's juxtaposed by reference to recital 15. And it's the last line on 869. Directive states, moreover, employment contracts of an indefinite duration, thus permanent employment relationships, are the general form of employment relationships, and that temporary agency workers must be informed of vacant posts in the user undertaking. And the key point is so they have the same chances as other workers to find permanent employment with the user, the end user. And again, just pausing there, the paragraph 51 of Advocate General Sharpston bears extremely close similarity with Mr. Justice Singh at paragraph 41 of Moran. It's a binary question. In relation to the remainder of the opinion,
I'm so sorry to interrupt.
Of course.
I could just say that lasting only a limited period of time, not permanent. She doesn't say lasting for a short time.
Lady, no, in none of the cases has either an Advocate General or the European Court qualified temporary by reference to shorter term, as advanced by Ryanair.
And I suppose at this stage, before we get to paragraph 56, you would say that it would be odd if an employee who has a vacancy for a permanent position is obliged to notify somebody who is there on a 6 months contract, but not somebody who is there on, say, a 5-year contract.
My Lord, precisely, that's the protective purpose of the directive. And again, Recital 1, Article 31 of the Charter, the broad reach, the protections applying to every worker. Looking at the legislation, the directive in context, if there was any intention to qualify, reduce the scope of the rights or the reach of the directive, one would have expected the legislature to have made that clear, as they did in the Fixed Term Framework Directive. In relation to the remainder of the opinion, that deals with the Article 5 abuse, and paragraph 54 on page 870, the Advocate General addresses whether or not a member state's under an obligation to impose a guillotine or ceiling on how long an assignment should be, and she rejects that at paragraph 54. It's a minimum requirements directive. Its wording and scheme indeed do not permit one to write in sharp-edged specific obligations that are absent from the text. That doesn't mean, however, that one can ignore or gloss over such obligations that the directive does impose on member states. And then paragraph 56, which I believe you were taken to yesterday, again repeating that it's a minimum requirements directive. It's clear that a member state remains at liberty to introduce such specific legislation. And then scrolling down to the last 3 lines, which she says is this: if successive assignments of the same temporary agency worker to the same user undertaking result in a period of service with that undertaking that is significantly longer than what could reasonably be regarded as temporary, that constitutes, in my view, precisely such an abuse. And paragraph 57, again, reference to oft-repeated successive assignments. The short point is the remainder of this opinion, and also the consideration by the European Court, is considering successive assignments. This is not a successive assignment case.
Logic of her position would perhaps, isn't your better point, it's about abuse.
Well,
Because the logic of her position would be not only that a number of successive assignments were abusive, but possibly a 10-year contract presented as being a temporary agency contract. Am I right about that?
My Lord, yes, and Mr. Bowers rightly accepted yesterday when he was addressing or showing the court KG, that he accepted this case, the Lutz case, is not about abuse.
No, but it might have been. It isn't, but it might have been. I'm not saying it would have succeeded. But I was just picking you up on the suggestion that the real distinguishing factor is this about successive assignments. The real distinguishing factor about Paris 56 onwards is that they're about abuse.
Yes, my Lord, that is...
The effect of 5.5.
Lord, yes. So 5.5 is two limbs, the general obligation to prevent abuse, and in particular the second limb deals with successive assignments, and that appears in the text of Article.
Yes, I see. Okay.
But isn't it a broad? I mean, I take the point that this case is about successive assignments, each of which individually is short term, but when you add them together, they're not. But the broader point is that as a natural use of language, the Advocate General appears to think that a time will come when something has gone on for so long that it cannot reasonably be regarded as temporary. And the period in this case seems to be about 2.5 years, which is half of what we're concerned with.
My Lord, yes, but the key point is this: it's in the context of national legislation which sets a ceiling, as we've seen, on the number of assignments, or at least the period of time by which a worker can be assigned. But the more fundamental point is this: Article 5.5 has never been relied upon to deny a worker who would otherwise fall within scope any protection of the directive. And that's why these provisions, or these passages in KG, have got to be approached with care, because the consequence of Ryanair's reliance on them would be to invert the very purpose of the directive. It would exclude those who the abuse provisions in Article 5.5 were explicitly designed to protect. And that's fortified or made good by the last sentence of paragraph 56, namely the protection of the temporary agent workers and prevention of abuses. So an end user can't rely upon what it subsequently or retrospectively asserts as an abuse to deny protection. That's not how the directive is designed to operate. And we just move on very briefly to the European Court. That's at divider 47.
46.
Sorry, 46. Apologies. Thank you. 46. And we can turn, I'd like the court to turn to paragraph 51. That's at page 885. sorry, paragraph 50, paragraph above, the last 3 lines, again, the court sets out the purpose of the directive. It's therefore designed to reconcile the objective of flexibility sought by undertakings.
So which paragraph did you say?
Paragraph 50 at page 885. And it's the last 3 lines. So the directive is therefore designed to reconcile the objective of flexibility sought by undertakings and the objective of security corresponding to the protection of workers. And again at paragraph 51, that twofold objective gives expression to the intention of the EU legislature to bring conditions of temporary agency work closer to normal employment relationships, especially since in recital 15, and there's reference there to, again, employment contracts of an indefinite term are the general form of employment. And again, the court addresses what is meant by temporarily at paragraphs 61 and 62. That's page 887. Before we turn to that, at paragraph 60, it refers to the trap that Advocate General Sharpston was considering. Member States seeks out member states to ensure that temporary agency work at the same user undertaking does not become a permanent situation for a temporary agency worker. That's what Article 5.5 is designed to prevent. Then in relation to the definition of temporarily, paragraph 62, though the directive does indeed refer to employment relationships which are temporary, transitional or limited in time and not permanent employment relationships, nevertheless states, in recital 15, article 6, employment contracts of indefinite duration, that is to say permanent employment contracts, are the general form of employment relationship, and that temporary agency workers are to be informed of any vacant posts that the user undertaking to give them the same opportunity as other workers in that undertaking to find permanent employment. So again, that chimes with the definition, or with Advocate General Sharpston's consideration that temporarily means not permanent, not indefinite, but limited in time, and limited in time without qualification, we would say.
So you say those are alternatives, do you, because of the word or? They can be either temporary or transitional or limited in time in order to qualify.
My Lord, yes. Anything which, any employment relationship which is not indefinite or not permanent comes within scope.
But in other words, something that is limited in time but not temporary or transitional is nevertheless good enough for your purposes, is what you're saying. Yes, I see. Thank you.
And I can move on to consider the ALB case. That's at divider 49, tab 49. So it's in the third bundle. And the court hasn't been shown this authority, but before I get into the thicket of the facts and what it was about, by way of headline, just make 3 general points about the ALB case. First, it supports Mr. Lutz's case.
Sorry, which case? This one am I looking at? You've got
Yes, LD versus ALB.
All right. Okay. 3 points, yeah.
3 points. First, it supports or buttresses our case, or Mr. Lutz's case, on the temporary permanent dichotomy, that it's a binary question. The second point is that it provides the answer to Ryanair's ground 2, that which advances the proposition that the nature and the purpose of the work have to be considered. That's certainly not supported by the ALB case. And thirdly, it disposes of MCG's ground 4 that the tribunal focused on the wrong contract, that it should have focused on the contract between MCG and Ryanair. In relation to the facts, they start at page 944.
Perhaps just to note, this is another post-Brexit case.
It is. So 944, paragraph 15, we can see that the employer operated a clinic, LD was employed in that clinic. There was a transfer situation in paragraph 16 where the employer transferred various functions to Company A, which was a wholly owned subsidiary. And paragraph 17, LD, as was his rights under the Acquired Rights Directive, transferred or objected to his employment transferring to Company A. But the issue, or the giving rise to the dispute, was summarised in paragraph 18. Nevertheless, he was required to work for Company A, which provided him with technical and organisational instructions, and pursuant to German law, the employer ALB had the right to assign LD permanently to Company A and Company A to issue instructions. Curiously, LD in paragraph 19 brought an action seeking a declaration he wasn't required to perform work on a permanent basis for Company A. So that sets out the backdrop of it. Paragraph 23.
So the TVOD is what? That's the Austria or Germany, I forget.
I believe it was Germany.
This is the German equivalent of TUPE, is it?
My lord, that's my understanding.
Yes, I see.
Paragraph 23 sets out the doubts that the National Court had as to whether or not the directive on temporary agency work applied to this particular situation. And the European Court agreed that it was right to express doubts because this fell outside of scope. And we can move forward to page 948.
So where do we see the European Court agreeing, the Luxembourg Court agreeing that it's right to express doubts?
Well, my lord, I'm coming to that.
Oh, I see. Okay,
Yeah.
sorry.
No. So page 948, paragraph 40, the court refers to what it describes as the literal interpretation of Article 1.
Which paragraph?
Paragraph 40. And then paragraph 42 refers to the wording of Article 1 of the directive and the definitions, concepts of user undertaking an assignment within the meaning of Article 3(1)(d) and E, that the employment relationship with the user undertaking is by its very nature temporary, and it refers to KG, which we've already looked at. And then...
Sorry, I'm being slow. When it refers to the employment relationship with a user undertaking, it isn't an employment relationship, is it? The employment relationship continues to be with the agency.
My lord, yes, it's the assignment which is temporary.
Okay.
Your lordship is correct. And then paragraph 43, the court makes the key point that the focus is not on whether the intrinsic duties of the job undertaken are not permanent or are otherwise covered. And we can see that from paragraph 43. It should be recalled that the term temporarily, set out in Article 1(1), is not intended to limit the application of temporary agency work to jobs which are not permanent or must be performed to provide cover, as that term characterises not the job to which must be occupied at the user undertaking, but the arrangements for the assignment of a worker to that undertaking. So just to pause there and unpick the distinction. The distinction is this: the characteristics of a job done, whether it's to cover a permanent job or non-permanent job, or is seasonal, or is cover for absence, that is irrelevant to the statutory question. The proper focus should be on the arrangements for the assignment of the worker. That's what the focus has to be on. And my Lord, to address the point that you raised with me at the outset, what is it, what should the domestic court or tribunal consider in determining whether or not an assignment is temporarily or not? That is set out, the answer to that is set out in paragraph 44. In order for an employment relationship to fall within the scope of the directive, both where the contract of employment concerned is concluded and when each assignment is effectively made, an employer must have the intention to assign the worker concerned temporarily to a user undertaking. And my Lord, just to clarify, we say that in this case, the case of Mr. Lutz, the contract with MCG covered both contractual obligations owed to MCG and also specified the 5-year period of assignment and the terms that would govern that assignment. That's one.
Did it? It specified a 5-year term for the agreement.
Yes.
And it specified after the first year 450 flying hours. Suppose he'd only had 450 flying hours, or even in the first year he could have had less, but it's not overcomplicated. Suppose in year 2 he has only 450 flying hours, which means he's only occupied for about half the year, and he's left off the rosters for half the year. Is that all still one 5-year assignment? Or isn't there an assignment each time that Ryanair, say, put him on a roster?
My Lord, in the interests of full transparency, the case wasn't advanced like that below. It was advanced on the basis that there was a 5-year term and that was the assignment. But we do acknowledge that Your Lordship has identified another way in which the assignment could be analysed.
Okay, thank you.
But either way, we say whether the focus is on Mr. Lutz agreeing to make himself available for 11 months of the year over a 5-year period, that suffices to establish temporarily. But the key point is, going back to ALB in paragraph 44, if one were to ask when Mr. Lutz entered the Dishford contract, was there an intention that he would be assigned for 5 years or permanently, there is only one answer to that by reference to the contractual documentation, which was never disputed in relation to that. So can I just move slightly off ground 1, but because we're here, in relation to Ryanair's ground 2, that the tribunal should have focused on the purpose and the nature of the work, whether it's cover work, whether it's seasonal work, whether it's a permanent role or not. Paragraph 43 provides a very clear answer to that. It's not the correct question. As regards McGinley MCG's ground 4, the tribunal should have focused upon the contract between Ryanair and MCG. Paragraph 44 disposes of that. Focuses on the assignment of the individual worker and the terms and arrangements governing that particular assignment. And just finishing off the court's reasoning, at paragraph 47, the court explains why this particular peculiar situation doesn't fall within the directive. And again, we have the permanent temporary dichotomy featuring again. Paragraph 47, in addition, a permanent transfer of the duties performed by a worker for the undertaking, which he's concluded a contract of employment to a third party undertaking, cannot give rise to an employment relationship of a temporary nature with the latter undertaking within the meaning of the case law. Makes exactly the same point as Mr. Justice Singh arrived at in Moran. And in terms of the definition, yes, paragraph 50 of temporarily, and again by reference to recital 15, which we've looked at, you can see at paragraph 50, the last 4 lines. It's clear from the case law of the court that the directive refers exclusively to employment relationships which are temporary, transitional, limited in time, and not permanent relationships.
And 51 goes on to make the point that it doesn't make any difference. The problem with abuse doesn't make any difference to the definition, if I can put it crudely.
Not exactly. So it fortifies the key point that you can't, it's not for an end user or a temporary work agency to say, Article 5.5 is engaged, for them to rely upon it in order to exclude the individual from protection. That's the obvious and common sense point. Lord, can I just address you very briefly by reference to Daimler?
Yes, I think we had that loose, but probably we also had it in that package that was added to the end.
I apologise.
No, I don't mind at all. I just wanted to know where to find it.
So
is it 1120?
Well, I want to start off by referring to Advocate General Tanchev.
Yes, that is 1120.
I'm grateful. Sorry, mine's not paginated. And before we get to Daimler, again, I think it's important to clarify what the case is really about. And we say it's about 2 things. Firstly, an abuse in relation to successive renewals under Article 5.5. And secondly, it's an abuse in the context of where the member state has exercised its prerogative to introduce more favourable protection to agency workers under Article 9 of the directive. And
Just give the headline point again. What's the second thing it's
second
about?
point it arises, the abuse is addressed, the question of abuse is addressed in the context of where the member state has exercised its prerogative to go beyond the directive and to introduce provisions which confer more favourable protection.
Yeah, thank you.
And in relation to the facts, paragraph 13 sets out the landscape in relation to domestic German law. It's page 122, I believe. And if I can paraphrase, the legislative requirements introduced with effect from the 1st of April 2017 place limits on how long a worker can be assigned temporarily, and we can see the passage quoted from paragraph 13, line 2, there's a reference to 18 consecutive months. So that was the limit. That was,
So where was that reference?
sorry, paragraph 13.
13.
And it's the...
I've seen it, yes, thank you. Got it, yeah.
And then there was an exception by reference to which a collective agreement could lengthen the maximum period of an assignment.
Yeah.
And we find that at paragraph 18 over the page.
So you get up to 36 months.
36-month extension. But in the context of the domestic law, although the directive came into force and was implemented in December 2011, the legislative amendment excluded periods of time occurring before 1st of April 2017. So it didn't apply retrospectively. And then in terms of the facts, NP we can see the bottom of paragraph 19. He was subjected to 18 extensions over a period of 56 months. So that's where the abuse comes. And paragraph 26, we see the questions that were referred by the National Court. And question 1 asks, is the assignment of a temporary agency worker to a user no longer temporary as soon as the employment takes place in a job which is permanent and not performed to provide cover? And then question 2, there's reference to a period of 55 months, that no longer to be regarded as temporary. It's important to note that both of those questions were reformulated by the Advocate General. And we can see that at paragraph 33. And 33.1 reformulates the first question by reference to Article 5.5. Does it preclude assignment of a temporary agency worker over a period in excess of 55 months to a job which is permanent, not performed for cover, as an successive assignment? And then paragraph 34, it simplifies, Advocate General simplifies questions, 2 questions. Is a law of a member state which prescribes a maximum assignment period to a single user undertaking of 18 months from 1st of April 2017, which expressly excludes taking into account periods of assignment prior to this date, in determining whether misuse of temporary agency work has taken place consistent with Article 5.5. So those were the 2 questions.
Bit of a shame, really, because as originally formulated, the first question directly raises our ground 4, doesn't it? And the second one tells you quite a lot about what's meant by temporary.
My Lord, precisely, yes. But the point to notice is that under question 34(2), by reference to the specific context of the national legislation introduced by Germany. So everything that the Advocate General provides, or the opinion in relation to that, and the consideration by the court, as we'll come to in a moment, is qualified by the context of the restrictions which existed under German law. Paragraph 37, the Advocate General addresses the meaning of temporarily, we can see in the heading. And then at 38, again supports Mr. Lutz's position, refers to the fact that the term temporary in Article 1 is to be interpreted broadly in order not to jeopardise the attainment of its objectives or undermine its effectiveness by inordinately and justifiably restricting the directive scope. And again, there's a reference to, on its literal interpretation, Article 1.1 refers to the duration of the assignment of temporary agency worker not to the post occupied. Again, that's referring to Ryanair's ground 2, the nature of the employment. And then Lady Justice Lang referred to, or asked a question earlier on, what about other translations of temporarily? Paragraph 39, the Advocate General refers to Article 1.1, concerns temporary agency workers who are assigned to a user undertaking to work temporarily. Now, footnote 21 does refer to other languages. It's the French version, Bulgarian.
That was. I may have misunderstood. I thought Advocate General Sharpston suggested the word was intérimaire. There you are.
Well,
never mind.
Well, there's Bulgarian, German, Portuguese, Slovak, Czech, Polish, Dutch.
I will own
Yes,
up
so
that very few of those are helpful to me.
Well, Mr. Ford says that Advocate General Sharpston went to the dictionary, whereas
Oh, I see. Okay, thank you.
Advocate General Tanchev appears to have looked at the actual wording of the text. But we see at the end of footnote 21, there is the express reference to Advocate General Sharpston in KG that we've already looked at, and how she has interpreted temporarily.
But he says any nuances in the language versions are insufficient to generate doubt with respect to difference in meaning.
Lady, yes, precisely.
Actually, I don't know whether I put it in. Oh, it is Mr. Tancred, yeah.
What we can take from that is that there is a consistent line of Advocate Generals coming up with a consistent explanation or definition of temporarily, and those have been accepted by the court as well. And paragraph 39, third line down, it's the employment relationship between the temporary agency worker and the user undertaking that is temporary, not to the post which the temporary agency worker is assigned, there being no mention in the directive of the nature of the work, and there's nothing to suggest that the post to which the temporary agency worker is assigned cannot be permanent. Again, Ryanair's ground 2 found us on that particular point. And then paragraph 41, again, it's the last 5 lines of paragraph 41. Further, as pointed out in KG, the directive refers in recital 15 to employment contracts of indefinite duration, with this provision along with Article 6, establishing permanent employment relationships as the general form of employment relationship. The opposite of this is an employment relationship or assignment that is limited in time. Again, Mr. Lutz's position chimes with Moran, which chimes with Daimler. And then just to conclude on this, paragraph 44.
I'm being slow about this again. It's the same point that's nagging me. I see exactly why he says the opposite is an assignment which is limited in time. Why does he refer to employment relationship or assignment? The relationship will always, well, not will always be, but the relationship with which the directive is dealing is one where the employment relationship remains with the agency.
Lord, yes, but I suppose...
And so one's only looking at the assignment being limited. What's the employment relationship that's limited in time?
Well, my Lord, it's one of the purposes of the directive is to stimulate permanent employment with the end user. And it may be that the Advocate General's used employment relationship in a rather loose or expansive way by reference to Article 6. And you can see that in the last 5 lines of paragraph 41, that the aim or purpose of Article 6 It's the right to be notified of permanent posts.
I know what Article 6 says. But
Yes.
what?
My Lord, you're absolutely right. Unless the employment status changes of the agency worker, their relationship is with the agency. But it still assists.
I mean, you could have a situation, not our kind of case, but where the agent is only employed by the agency for the length of the assignment, and then just goes back on the books as a non-employee. Maybe that's what he has in mind. Anyway.
My Lord, that is conscious of time, but that is the Advocate General. We, again, apologies, I'm not sure what tab number it is, but we move to the court at 1098. And again, just a few points just to orientate through the judgment. Paragraph 15 at page 1103 sets out the position under German law we've already looked at. Paragraph 20 refers to the collective agreement increasing the ceiling to 36 months. And then, in our submission, this judgment's got to be approached with care and having regard to what was in issue in the main proceedings that were considered by the German court. And after having referred to 36 months, paragraph 26, page 1105, in that context, the referring court points out that NP seeks a declaration. What is that context? It is that context where there's a general prohibition of anything beyond 18 months, capable of being extended by up to 36 months by a collective agreement. That is the context. And at paragraph 27, it's quite clear, in those circumstances, the opening words, that is what the court is addressing. So that the circumstances which pertained under German law, where it was exercising its rights to, in one sense, to afford greater protection to agency workers under Article 9. And
wasn't the claim that really that the remedy for the abuse of successive assignments identified in Article 5.5 ought, under EU law, to be that he was effectively treated as having a permanent employment relationship with the end user, to which the court said no.
My Lord, that is correct, yes. So it's the introduction of a protective measure which wasn't retroactive in application, so it prevented him from relying upon periods prior to April 2017. So that was the barrier in that case, and that was the abuse.
Well, there was an abuse under EU law because there were a whole lot of successive assignments, and the remedy he wanted was to be treated as a permanent employee from the outset, and the court said, no, your only remedy is some kind of Frankovich claim against the member state for not implementing appropriate measures.
My Lord, quite, that is correct, yes. I'll turn to that very briefly, but in relation to the first question about temporarily, the court addresses that at paragraph 31. Where we again have the same wording as in the ALB case, temporarily not intended to limit the application to jobs which are not permanent or must be performed to provide cover. Again, it characterises the job, not the job, but the arrangements for the assignment. 33, none of the provisions of the directive concerns the nature of the work or the type of job that must be filled. Pause there. Ryanair's ground 2 has difficulty in relation to that. And then paragraph 36, again, the same point. The legislature didn't intend to limit the use of temporary agency work by permitting a temporary agency worker only to occupy a job which is temporary in nature. And then we have the same point at paragraph 37, the last 7 lines. In relation to the abuse point, that's addressed at paragraph 48 at page 1108. The court reformulates the question, and we can see at paragraph 51, that is the reformulated question. The question aims in essence to determine whether in circumstances such as those in issue in the main proceedings, I pause there, circumstances in issue in the main proceedings are as follows. The state has exercised its Article 9 right to a more favourable provision by reference to either an 18-month long stop or a 36-month long stop. That is the context by which the court addresses it. And in the interest of time, if I can move on to paragraph 63. What we have at paragraph 63 is the court's conclusion on this, and the renewal of, third line down, renewal of successive assignments in respect to the same job at a user undertaking for a period of 55 months constitutes a misuse of the allocation of successive assignments to a temporary agency worker. And it goes on to say, which will result in a period of service that undertaking that is longer than what can reasonably be regarded as temporary, in view of all the relevant circumstances, including in particular the specific characteristics of the sector, and in the context of the national legislative framework. No objective explanation. And you can see that Article 9 is engaged by reference to paragraph 70.
Do we need, you are very short of time, do we need all this detail?
My Lord, the Ryanair produced the authority last week, and I was waiting to see what was said about it. But the key point is this: if it's going to be said, Daimler is authority for the proposition that an assignment of lasting 55 months is not temporary.
Yeah, I see. Yes.
Then
you made that point some time ago. We're just...
Yeah.
Sorry, that sounds ruder than I mean.
No, my lord.
But I'm just wondering whether... We've seen the bits we need to see to make your point, haven't we?
My Lord, absolutely.
Yes.
So, my Lord, just very briefly, in relation...
Well, yeah, you haven't got any more time, have you? I mean, it depends how important these points are. I don't want to stop you. If you're listening to repeat or recapitulate, don't.
Don't. My Lord, quite well. Hopefully, the submissions I've addressed you on ground 1 temporarily, Ryanair's ground 2, nature and purpose of the work, and McGinley's ground 4. Unless I can assist any further.
No, that's fine. I'm not trying to cut you off. There's some substantive point you haven't made, but if you're just... I think you have made everything you want to say. Very well. Thank you very much.
Grateful.
Yep. Yes, Mr. Brown.
My lords, my lady, what I propose to do then, by reply, is to confront the difficult question at the heart of the employment status issue, and that is whether Parliament did intend for Mr. Lutz, as an agency worker, to have EU rights, or Lim B worker rights as the case may be, enforceable against the agency, MCG, under the CAWTR. And it is, we say, important to note the consequences of the point which the court raised with Mr. Lutz in the conclusion of Mr. Ford's submissions, namely, well, what does Mr. Lutz say about the absence of Regulation 36 in the Civil Aviation Working Time Regulations? And Mr. Lutz's clear answer is that it does not matter because it would not matter under the working time regulations either, namely that it is conceptually impossible as a matter of EU law in a tripartite scenario for the worker to enforce their rights against the hirer or the end user, and therefore, assuming that they are not in fact an independent contractor, it must be taken in any case that those rights are enforceable against the agency. That is the crystallisation of Mr. Lutz's argument, and one needs to be clear about what the consequences of that analysis are. The first point is that the complexities of triangular employment relationships, such complexities having been acknowledged and recognised for many years, are not in fact complicated at all, because on Mr. Lutz's analysis, you simply enforce against the agency in any case.
What's wrong with that?
Nothing wrong with that if that is what Parliament intended, but that then means that there isn't, as it is described by Mr. Ford in his article, the concept of a fissured employment situation in this triangular situation. That fissure does not matter, because in any case the rights were intended to exist vis-à-vis the agency. And that does mean that Regulation 36 does no work at all in the working time regulations context. And that means that Parliament effectively was legislating for something which is entirely redundant.
You say Parliament, you mean the Secretary of State?
I say the Secretary of State, powers conferred by Parliament, but my lord's absolutely right. It does mean that Regulation 36 has no consequence at all, and the debate that has raged for many, many years, whether in fact there is a sufficient nexus to found an employment relationship as between agency and worker, was always a sterile debate, because it is said those rights have always existed as against the agency. So it is a very striking submission and a very striking...
Well, all right. I take the point, but nevertheless, what's wrong with it in substance as an answer?
Well, how does one get to it? Because on the face of the regulations, the question is employment for. So one has to look at that. So one takes this from first principles. One goes back to relevant provisions, so Civil Aviation Working Time Regulations.
Hang on 1 second. Yeah, sorry. So we're going to the regs.
We're going to the regs. So page 19.
Yeah.
Crew member means a person employed by. So the foundation for the entire submission has to be that the words employed by, in the context of the tripart arrangement, are intended to mean employed by the agency.
Well, hold on a minute. If you go further down, employment in relation to crew member means employment under his contract, and employed shall be construed accordingly.
Yeah.
Now, one way of approaching that would be to say that where the contract is directly with the aviation company, that's that employment, and where the contract is with the agency, that's that employment, using employment in the broader EU sense.
My lady, I'm very sorry, I'm not...
It's not a clear, sorry, I haven't been clear.
Yeah.
Crew member means a person employed to act as a member of a flight crew, blah, 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 by an undertaking. So, employment in relation to crew member means employment under his contract.
Yeah.
And employed shall be construed accordingly.
Yeah.
Why can't that embrace both conventional employment under a contract of employment and employment, using that in the broadest EU sense, in a contract with an agency.
It can and it does.
Right.
Yeah. So I accept that. But that's not the submission that's being advanced here. The submission that's being advanced by Mr. Lutz is that, in terms of who is the employer question, the submission is it is never the end user because of the absence of a contract. That's the point by reference to James and Greenwich, which is maintained.
Yeah.
And it has to be employment by the agency. Now we say...
Well, that's only where the agency is the employer.
Exactly.
Yeah.
But clearly, if anyone's the employer, you're the employer, the paperwork says so. Why would it ever be Ryanair, unless it were necessary, and this is what I was obviously flirting with at some points, unless it were necessary to give effect, to make the regs workable?
My lord, the difficulty is one has to take this in stages. So everybody accepts that it is possible. Well, that's not right. MCG has always submitted that it is possible for there to be a relevant employment relationship between MCG and a worker, and it is possible for there to
When you say a relevant employment relationship,
an EU employment relationship.
yes, of course, yes.
Yes. So
There's no dispute about that.
Yes. So using the word relevant as a shorthand for the autonomous EU concept.
Yeah. Okay. Well, why not put a worker relationship then?
A work relationship, very well. So MCG has always said it is conceptually possible for there to be a work relationship between MCG and the individual, or the user and the individual. That has been MCG's case. So we say both of those are conceptually possible, of course, because
I don't even understand why you're saying as if it's a concession or the user, but in what circumstances could it ever be the user? On the MCG's paperwork and the way this has been set up.
My lord refers to the paperwork, but the response to that is, first of all, that the EU autonomous concept of worker does not require a contract.
No, but there is one.
Yes, and the second point is that Uber tells us that one doesn't even start with the contract. The contract might be relevant because it might be a correct description of how the parties behave in relation to each other. But that's as far as it goes. So the fact that the contract says one thing does not itself answer the question, because that is precisely the mischief of Uber. What we are looking at is not what the parties have provided for pursuant to the contract, but whether Parliament intended for the statutory rights to be conferred on the individual and owed by the agency. And those are different questions. So one does not answer the question about parliamentary intention by looking at what the parties decided, and that's Lord Leggett's judgment in Uber.
Yes, but the focus of the civil aviation regulations is the contract.
It makes reference...
That's the vehicle by which everything happens.
But everybody has accepted that there is no conceptual difference between the civil aviation working time regulations and the EU autonomous concept of a worker relationship. Yeah. So there's no different approach under these regulations than as applies as a matter of EU law generally. What is important about these regulations is that they do not face up to the problem of a fractured employment relationship situation that arises in the context of agency work. They simply do not do it. That has to be done by Parliament. It has to be for Parliament to determine whether, in fact, these rights are to be extended in the concept text of an agency relationship. See Regulation 36 of the Working Time Regulations. Because the only other route to securing that protection is by Allenby, effectively, by saying, as indeed Mr. Lutz does, that Allenby in the Court of Justice requires or compels that conclusion. And we say that is plainly not right.
Well, it is my fault. I'm just not understanding the difficulty, because on the literal construction of these regulations, there is a contract. It's either a contract with the Ryanair in the case of a permanently employed pilot, or a contract with MCG in the case of a contracted pilot.
My lady, the answer is because what matters here are the words employed by, not what is the contract, who is the contract with, look at the arrangements.
But perhaps I haven't understood your point.
Yeah.
Of course, employed by is important. You've got to be employed by someone, but it says employed by an undertaking established in the UK.
Yeah. So, well, that tells you nothing about who your employer is.
No, quite.
Yeah.
So then you do the ordinary test,
Yeah.
and despite what you say about the contract not being the starting point, I need to take a lot of persuading that some Lord Legate has said I'm not supposed to look first at the contract. I look at the contract, I see the contract with MCG.
Well,
Why should I look at anywhere else?
because that is not asking the relevant question, which is what is the nature of the contract? Because contracts come in different shapes and sizes.
Yes, but it's a worker contract, otherwise we're not in business at all. It's a contract to provide services.
Well, that's the question then. So there's different points there. The point that I'm addressing at the moment, and I'll come on to my Lord's point about
Sorry, no, you
terms.
stick with your point.
The point that I am focusing on here is that what we are told from Uber, what is clear, is that this isn't a question of contractual construction. This is a question of parliamentary intention. And that is a fundamentally different exercise.
Yeah.
So in terms of the question of parliamentary intention, you have to ask ourselves by reference to the relevant legislation, was it the intention of Parliament that MCG owed these rights or these obligations to Mr. Lutz? And the answer perhaps may be yes, it may be no. But if the answer is yes, one has to ask the question, well, how is that the intention? Where is that discernible in the regulations? Because the only relevant words that are used are the words employed by. So then the question is, well, is it the case that Mr. Lutz was employed by MCG? That is the process of statutory interpretation with which we are concerned. The next question then is, well, what does employed by mean? Answer to that is control and subordination. See Allenby as applied in Uber. Has that been satisfied on the facts of the case? I'll make further submissions in a moment, but we would say no, but that is the exercise. What one does not do is approach the question on the hypothesis, and let's just take it as a hypothesis for the moment. Assume that there is very little control or subordination as between MCG and Mr. Lutz, just for the purpose of the argument.
Well, actually, okay, I have no difficulty accepting it as a matter of fact.
Right, and assume then that on the face of the legislation it does not appear that he is employed by MCG, because there is an
That's what doesn't seem to me to follow. Because if you are employed as a pool of workers to be supplied to third parties, which is a perfectly recognised model,
yeah.
the nature of your employment will be by the agency is that the agency directs you to go and work for somebody else, and doing those tasks for the somebody else, you will be under their control or direction.
Very well. In which case, you don't need Allenby or any of the other case law, because my Lord is answering that question in an entirely orthodox fashion by saying that the nature of the relationship, simply on its own terms, and going back to ready mixed concrete or wherever one wants to go, is in fact a worker contract. But that is not a conclusion that has been reached in the agency worker case law thus far, and that is why it's inherently problematic. Because it does require there to be this look-through process, or this transposing of the obligations as between the user and as between the agent. And that is the central difficulty with all of this. Because I accept my Lord's proposition that that is a possibility, but it is wrong to say, as indeed Mr. Lutz does, that it is an inevitable conclusion as a matter of either domestic law by reference to contract or EU law by reference to Allenby or any other case. So we say that in truth this is precisely the same as the Uber situation for this purpose. I appreciate that from the perspective of the court, Uber doesn't actually deal with the tripartite situation at all, and to that extent it doesn't cover all of the area which interests the court. But in relation to the perspective of my client, the sole question is, does MCG employ Mr. Lutz? And on these factual findings, that only allows for one answer: no, it does not. So that is
Only allows one answer.
yes.
Why don't you employ him?
Because of the factual findings of the tribunal.
But the factual findings of the tribunal are simply that his day-to-day tasks are controlled totally by Ryanair.
Yeah.
But why does that mean that you don't employ him?
Insufficient control and insufficient support.
But that's not the only test.
By reference to Uber, that is that is essentially the test.
But this
so
isn't an Uber case, because this is a case that's regulated by a whole lot of interlocking protections derived from EU law.
No.
So we're not.
Uber, the rights that are thought to be enforced in Uber are working time regulations rights and others. But Lord Leggett makes the point that all of the statutory rights in play in Uber all are the same in terms of the relevant legal tests. There's no difference between the different statutory rights in Uber, and it is the same statutory rights that arise here. So it is, for those purposes, on all fours with Uber, because it's a working time regulations claim in each case, and the relevant and only question is there a sufficient worker relationship so as to result in the conclusion that Parliament intended for these rights to be conferred in this situation. That's the issue in Uber, and that's
Can I
the issue
suggest
here.
there is a difference, because this is a situation that's also governed by the agency working regulations, which deal specifically with this kind of situation, and in short, the upshot of which is that there is a relationship of worker between the person who's placed by the agency with the end user and the agency.
My lady, on ground one, which is what I'm specifically concerned with now, the ground one, solely the working time regulations claim, the CAWTR claim, there is no difference with Uber. My lady's absolutely right. The other grounds raise other issues, but I'm solely concerned with ground one at the moment. So there is no difference. The only issue is there a relevant worker contract? That has to be addressed on its own terms by reference to the claim that is brought against MCG. This is fundamentally very straightforward. As against MCG, it is conceptually possible that there could have been a worker contract. MCG could have extended contracts in express terms, which are properly described as being employment relationships, but that, we say, did not happen on the findings of the tribunal. And what is necessary then is to analyse whether the findings of the tribunal support the conclusion that there is a worker contract. And I've taken this court through all of those findings, which indicate very clearly that they do not. So this is why Mr. Lutz has to resort to an alternative approach, because the straightforward approach, which could just as easily have referred to no EU law whatsoever, he has to in fact say, well, actually, you are compelled to effectively impose these rights upon MCG because of cases such as Allenby. That is the way the case is put.
But this all depends on your... To me, you said the straightforward thing is the obviously isn't a worker for MCG, and Mr. Lutz has to resort to all these artificial contortions to get into one. But you still haven't persuaded me, and you must have one more go, that the straightforward analysis isn't what the paperwork says, and what is an absolutely standard model in the UK and in the EU, under which agencies continue to employ people, but supply their services to end users. And whether it's irrelevant whether it's an employment relationship or a worker relationship, that relationship is with the ostensible employer, that's to say the agency. And your only answer to that, I think, is read that passage from Uber, and all that has been ripped up. Because in any case, you must say who actually tells you how to do the day-to-day work, who organises your working life. That must be the employer. And I rebel against the idea that that's what Uber was concerned with.
I have two answers. The first is that the assumption in my Lord's point then is that under the standard model, if this is a standard model, is that the agency will inevitably have some sort of worker contract with the temporary agency worker. And I would say that that is not the model. So the tripartite model does not work on the basis that there is in fact necessarily that worker arrangement at all.
Well, I didn't say necessarily. Although you can have them when they're really just a recruitment agency.
Yeah.
But then they get taken onto the books of Ryanair, which your client never was.
Yes. So sometimes you will have the situation in which they're introducing. I accept that. But I would not accept the proposition that the standard model results in a situation in which there is usually, or frequently, or inevitably a worker contract as between the agency and the individual.
Okay, well, that's your first answer.
Strong evidence for that is the existence of Regulation 36, because that is precisely designed to confer rights in this situation. The whole presumption in Regulation 36 is no worker contract. One sees that in Regulation 36 itself. But this goes back to my starting point, that Regulation 36 is a dead letter on this analysis.
Yes.
And that is improbable. In terms of the Uber point itself, if one can look at please at paragraph 85 at 913,
So where are we looking?
Uber.
Yeah.
So, same section about definition of worker.
Which bundle is Uber in?
Uber is in bundle 3. You have 47.
913, I think you said.
Yes, well, 912, just in terms of where we're on the judgment then, so 912 is the heading applying the definition of a worker. And at that point the court has written agreement is not the appropriate starting point, but then that is developed a bit further. So reference then to familiar cases, Auto-Cleanse and Carmichael and National Power. So Auto-Cleanse, true agreement will often have to be gleaned from all of the circumstances of the case of which the written agreement is only a part. And Carmichael and National Power with the casual workers. If I could invite the court to read 84 before I make submissions then on 85.
Yeah.
85, Carmichael, no formal written agreement. And Auto-Cleanse shows that in determining whether an individual is an employee or other work for the purpose of legislation, the approach endorsed in Carmichael is appropriate even where there's a formal written agreement, and even if there is an entire agreement clause. This does not mean that the terms of any written agreement should be ignored. The conduct of the parties and other evidence may show that the written terms were in fact understood and agreed to be a record, possibly an exclusive record of the parties' rights.
We read it, yes.
Yes. Well, the point I make then is that the suggestion that the contract is not the starting point is helpful in that it indicates that what the tribunal actually needs to do is to look at how the parties interacted by reference to each other. So what was their actual behaviour? Because that is what matters And ordinarily, the behaviour will be regulated by the contract, but not inevitably. And it's for that reason that where there is a written record of terms, what needs to happen is that the tribunal needs to analyse those terms if they're being relied upon by either party and determine whether in fact they do truly record the basis on which the parties had agreed to interact by reference to each other. I use the language of interact because the word contract is potentially dangerous here. And what the tribunal hasn't done is the exercise which Mr. Lutz carried out in his submissions, which is to go through those agreements and start making detailed submissions about what the clauses all say and mean, because that fundamentally requires some analysis by a tribunal in order to determine whether in fact they do truly record how the parties behaved. Now, it's not a question of sham as such, it's a question of identifying to what extent the real relationship was in fact potentially different from what is set out in the written agreement.
I hope this is not splitting hairs, but what Lord Leggett actually says is that the written contract is not the starting point in determining whether an individual falls within the definition of a worker.
Yeah.
So you look at what the worker is actually doing and all aspects of the relationship. But the question, once you have determined, as we have here, as I think you submit, that Mr. Lutz is a worker, then the question, by whom is he employed, is a separate question to which one obvious place to look, perhaps the starting point but not the end point, is any written agreement which he has with anybody.
Absolutely, and in most cases the agreement is likely to be the answer to the question, because in the majority of cases things work as they should and parties behave in a way which is consistent with what they said they would do in the contract. So it's only in cases and situations where there is the mismatch, which has been identified in this case, where one actually needs to look further. And this arises in the context of casual workers, it arises in the context of fractured employment relationships, and one needs to then go further and try and characterise what in fact is the true relationship, who is carrying out the necessary control, and to whom is the individual actually subordinate.
Well, you're making your points very forcefully and clearly, but probably because we are coming back on you, you're making them fairly repetitively. And
can I just ask a question?
time is short, but
may I
not
just,
too short to answer my lady's
I'm
question.
so sorry. Can I just ask a question about Regulation 36, on which you place quite a lot of reliance?
Yeah.
These regulations are dated 1998.
Yes.
They predate the European Protection for Agency Workers. And what I would suggest is the reason that Regulation 36 specifically brings agency workers under this umbrella is because that was necessary at a stage when they weren't otherwise protected under European law.
Well, if they weren't protected, then Allenby, which is based on the treaty, etc., does not then provide that protection.
Well, this is just a point about the timing of when the various provisions came into force. So, so Regulation 36 predates the directive about agency workers.
Yes, but this is working time. So we're in the specific context of working time. The point I'm making about Regulation 36 is that if agency workers were always in scope because of the conclusions reached in Allenby, which presumably reflect fundamental principles of EU law, then this is simply not required.
Well, don't worry about whether they were always in scope. They clearly actually became in scope once you had the agency workers protection introduced by the directive that postdated the 1998 regulations.
But the agency worker regulations is doing something different to it. So the agency worker regulations is providing for equal treatment much later in various different respects. This is a very specific provision conferring working time rights in 1998. So it's doing something fundamentally different from the agency work regulations. I'll make my other points briefly, if I may.
No, I mean, you're right to focus on this point because it's central, but we've done it to death, at least from a reply point scope. Yes, what are your other points?
On the Charter, it is clear we say Article 31(2) does not establish any normative right itself, and all of the authorities to which you were taken make reference to the fact that the normative right, i.e. the 4 weeks, has to be contained within the directives made under the treaty itself. Insofar as this is being described as a cause of action, as how the Vice President put it at one point, then the difficulty that Mr. Lutz has is that that is not a claim proper to the Employment Tribunal at all. If this truly is some sort of freestanding claim, there's simply no jurisdiction to determine it. The tribunal could only determine rights which are confirmed by statute. That has to be the appropriate vehicle. Maybe a late point, but it's jurisdictional, and it does turn on how this is properly to be characterised. So we say that this cannot add anything in addition or independent from the statutory rights, and the claim has to stand or fall on the statutory rights, not these for that jurisdictional reason. On Angard, I appreciate I'm in a minority on this question of, well, what supply do you look at? Although I do say that my interpretation does find support from Judge Auerbach. He plainly is of the view that the relevant supply that one looks at here is the supply as between the agency and the end user. And that must be right. One can test it this way. What if the agency did have a permanent employment contract with the worker, but was supplying then on 2-3 day assignments? So that supply is then clearly temporary, but does it cease to be temporary because of the existence of a permanent employment contract with the worker? That would be very, very odd indeed. So I say that that demonstrates that my interpretation must plainly be correct. Unless I can assist the court.
No, thank you, Mr. Brown. That was very helpful.
My lords and my lady, if I can be fairly brief.
Can I just ask one question of Mr. Ford?
Of course.
This point hasn't come up before. At the moment, it seems to me to be good. If Article 31 is a freestanding cause of action, why has the Employment Tribunal got jurisdiction?
Well,
I think I know what the answer is going to be.
If you remember, my lord, the tribunal has freestanding jurisdiction to hear claims under direct effect of directives. It has
that goes right back to Albion and all those.
Exactly.
Things.
It has the standing to hear direct claims brought under Article 41 of the treaty.
I think should stop there. It's a very short point, Mr. Brown.
Absolutely, it does. But this is freestanding from those provisions.
No,
that's the whole logic.
No, but the point was this, that in the early days of the, you're too young to remember, Mr. Ford, clearly. Mr. Ford Herbert should sit down.
Discrimination law on that.
Mr. Ford, I'm addressing Mr. Brown. There was a conundrum about freestanding direct effect rights, which did not fall within the prescribed statutory definition of the employment tribunals. And there was a bit of flirting about that, but eventually it settled down. Right? One of the cases is called Albion, but it may not be the final one. That a corollary of there being a direct effect of EU law in the employment field was that it should be heard by the appropriate employment jurisdiction, the appropriate employment tribunal, with a small t being the employment tribunal. That would surely apply equally to Article 31. If there is a freestanding claim under Article 31, which is freestanding and has direct effect, the obligation on a member state is to give it effect in the bit of its legal machinery that deals with claims of that character.
Well, let me, if I may, reserve them in the sense that if we do disagree, we'll have to tell you why in a very short round.
Well, let's not spend any more time on it now. That's how I see it at the moment. I mean, and it sounded like a clever point. It was a clever point. when you raised it, but there may be a reason why it's only just occurred to everyone.
No, well, our real point, obviously, is that this does not establish a right that it was independent of the directive.
Yes, well, that's the substantive point. Very well. Mr. Bowers, I'm sorry to interrupt you, but I thought I'd better get that out of the way.
Yes, indeed.
Mr. Brown was only recently off his feet. Yeah.
So if I could deal firstly and briefly with the point as to whether Ryanair could be the appropriate employer here. And
Yes.
just to summarise really the paragraphs that I gave you yesterday, we say that MCG were involved in the taking on process, they were involved in the payroll, they were involved in allocation of holidays, they were involved in training requests, they were involved in ensuring that taxation were complied with. And my instructions are indeed that the audit reports were carried out on a yearly basis, although that wasn't in evidence because the point didn't really arise.
We should ignore it.
Discipline and dismissal. If a body is involved in all of those, we say they are a very strong candidate to be the employer. And Mr. Lutz didn't argue otherwise. And we would invite the court not to unscramble that. Now, I know my Lord, Lord Justice Underhill was concerned by the effect of the rest break provisions, Regulation 7 in the Civil Aviation Working Time regulations. I won't take you back to that, but it's Authorities Bundle 1 for page 22. We submit that Mr. Ford is right. This is a non-delegable duty, and if it requires the cooperation of Ryanair for it to be implemented, then they must so ensure, whether by contract or some other way. And it's noticeable, and I won't take you back to it, that there is an appointed liaison captain between MCG and Ryanair provided for in the contract, and that's supplementary bundle divider 10, page 51, paragraph 13. You were taken to that before. So if I may move on to 6, I hope brief points on temporary. Firstly, ultimately, we are concerned with the definition of temporary. We say the natural meaning is short term. We say, secondly, that Mr. Brittenden's very careful history of the directive in the context of the predecessor fixed term workers directive emphasizes that if the definition in the agency workers directives had indeed been fixed term, then it would have clearly said so. Or, of course, it could have brought in scope all agency workers. But instead, it chose the concept of the temporary agency worker, and that has to be given some scope. Thirdly, the ALB case is after the Brexit date. It is for the court to consider whether it does give assistance or otherwise. We do emphasize the reference in that case and the other case to limited in time, which we read as being short term, limited time, and for the reference in ALB that is page 949, paragraph 50. And just on a very small point, my Lord Justice Underhill suggested that the TVOD, which was under consideration there, was the German 2P. In fact, it's a collective agreement, as one can see.
Is it a collective agreement having the same effect?
Yes, it deals with transfers. It's Authorities Bundle 2, Divider 49, page 943, paragraph 13. Fourthly, JH and Daimler, we say, clearly see the question of the length of time as important. Although it arises in an abuse situation, it's really the other side of the same coin, because it goes to definition. It may be too long. The reference in JH at footnote 21 on page 869 in the French is to transitory, which we say is a paradigm definition of it. Limited period of time, short term. Fifthly, in Daimler, paragraphs 57 and 58, Authorities Bundle 3, page 1110, we emphasize paragraphs 57 and 58, which say that it is for the
This is the court at the court.
Absolutely, yeah. My lord. In the court, that it is for the national courts to decide what is temporary, and you know our submissions on that. Sixthly, in our case, the assignment is most naturally seen as the 5-year period of assignment to Ryanair. Obviously, he didn't work every day or every shift, but then no worker would work every day and every
Well, that's
shift.
not quite. I mean, this is the point I floated, but everybody has told me we shouldn't decide the case on this basis.
Well, it's certainly
argue below, but just so you understand what the point is, of course, if you're assigned for 6 months, you don't work 180 days. You've got weekends. You will have holiday within that 6 months. But the point I was making was that, as I understood the structure here, it was open, at least, to MCG not to allocate him for the whole of that period, even allowing for holidays, weekends, and rest time.
Well, in our submission, that wasn't argued below.
Well, that I do understand.
Not only that, my lord, the evidence was not given as to the precise nature of MCG, what they would do in a particular situation. The reason it wasn't was because it was never part of the case. So,
well, Mr. Britton accepted that, so I will behave myself. But I may float it as a possibility, but I will not decide the case on this basis.
Well, if I've got as far as that, my lord, I won't say anything more. And the final point, which actually is the seventh, is that my learned friends in their skeleton argument, but I think not orally, were taken with our point being too uncertain to work. We deal with this in paragraph 37 of the skeleton onwards. I didn't have time to deal with it yesterday, but I hope that you will read that before reaching judgment. And finally, may I remind you of what Byron said. This is Lord Byron.
All right, you got this out of Harvey, didn't you, Mr. Rather than from your extensive reading of the Romantic poets.
Well, my lord knows it already, but if I could just indulge us.
Yes, of course.
For those of us who aren't extensive readers of Harvey.
Come on, let's have it. Let's have it.
Nothing's permanent among the human race. That is my final offer to the court.
Yes.
Yeah,
Well, it's always good to end with a bit of poetry. I agree.
Thank you, Noel. Is there anything I can assist the court with?
Thank you very much to the entire teams, which extends not just to counsel but to those behind who will, I'm sure, have contributed for sophisticated and clear arguments on point, obviously, of some real significance for the parties and others. We will take time to consider our decision. Judgments will be circulated in draft in the usual way for correction of typographical and other minor factual errors, not for the purpose of giving you a chance to re-argue the case, also so that you can prepare a draft order dealing with any consequential matters or brief written submissions on the order if there are points of dispute. The draft judgments can obviously be circulated beyond the lawyers to the extent necessary for the legitimate purposes, but it must be understood that is only for those purposes. They will remain embargoed, and any breach of the embargo beforehand could constitute a contempt of court. Thank you all very much.
Thank you.
All right.